Yes, welcome to the No State Project here on LRN. Oh, actually, making my first mistake. It's actually just on my YouTube channel, No State Project. And you can get subbed at, of course, on my YouTube channel. So we're going to start doing a lot more of the role-playing sessions, and so we might actually put them and do them live right here on my YouTube channel. So definitely get subbed for that. I want to thank. I had a cable that was a problem. So I was unable to do the show on Saturday. So the reason for that actually wasn't the microphone dying, it was the cable that was gone. But, you know, being on the road, being out of town, and having it happen almost at the, within, a half hour or so of the show starting, didn't work out too well for me trying to get that fixed. So I do apologize for not being able to do the show on Saturday, but we are back here live, commercial-free, for episode 78, live from the fortified compound in Mesa, Arizona. And, of course, want to thank the guys for stepping up and so quickly helping show some support for the big broadcast. Of course, we got the dude and Jan, one of our Canuck friends up there. I do appreciate that. And also the support also from Don, who is a friend I did some work for a number of years ago, and he supports the show on a regular basis. So I do appreciate that. So Government Data does have a full model on what we use to get these tickets and complaints thrown out. And contrary to what a few fringe people, commenters on one, and I do appreciate the support so far for the latest video, 5 tips on how to be more effective in court. We have had success. We've had success. And it's not just 1 or 2 here and there, and it's not just because the police officer didn't show up. It's because we are launching a good defense. A good defense begins, at least, with challenging the claims that are being used against you. So, what you're not seeing with the few people who are commenting negatively is they're not actually commenting on the video. They're not commenting on the tips in the video, because I defy anyone to show where the tips in that particular video would not help you be more effective in court. Obviously, any half-idiot who's ever been to court before and understands logic is going to say, well, yeah, of course a leading question is going to be a lot more effective than an open-ended question. Of course. So they're not, so far no one's been able, but, we kind of expect that. Yes, I did hear, I'm glad that, Bao is free. He did a few months, apparently, there in the Dallas area. So hopefully somebody can give us a call and let us know a bit about what's going on with Bao. I don't know if he got released because of a habeas corpus. They would have told me, so it's probably not. But maybe that was just the time that he was ordered to serve. So it sucks that he had to do that. I would say that there would probably be a huge claim against the county's insurance. So we'll see about that. To get back to the comments, there was one that somebody pointed out to me. It was not on one of my videos, but it was on one of those videos that allegedly debunking me and my material. And so a point of contention, and this is a common thing, even though I've answered it like 1,000 times. I'm like a broken record on this. People will say, well, I asked Mark what evidence would satisfy him that the laws apply. And he never answers. All he does is shuck and jive, bob and weave. He never ever gives an answer. Well, that's not actually true. It's the whole thing about, I have some like 8 gigs worth of shows in the podcast, and that doesn't even include the video, which is probably about half a terabyte at this point, where that is absolutely just not true. So, I don't know. I don't think something like that would actually, deter somebody from actually defending themselves in court, by using the Socratic method and challenging sacred cows, not allowing the prosecution to have a free pass just because you think it's true. But I'll address it again. So the question is, what evidence would satisfy me, that the laws do apply? And, I always say the same thing. There's that key again. It would have to start with the rules, because that's all law is it's a rule. it would have to start with being voluntary. That would be some of the evidence. That a voluntary agreement there. And we're talking about laws or rules that create obligations on people, not just, making people aware that self-defense is morally justified, that if you are attacking me, then it's morally justified for me to use force to put that down. Okay? We're talking about whether actually creating an obligation on you. So that's where it begins and ends. It's a voluntary agreement. Now, the other part I talk about is that the evidence would have to overcome and negate the actual evidence we have now that they're just men and women forcing, everyone to pay them. I give the actual evidence. And so it's pretty irrefutable. I hate to say that, but it's pretty damn near irrefutable that they are just men and women, and they force strangers to give them money. Now, they do this under the guise of protection, but the guise doesn't matter. What matters is the force. What matters is the violence. So, evidence, and again, here, the burden of proof, if you think these laws apply, the burden's not on me to say, well, this is the evidence that I want to see. No, the evidence is up to you to present. If you're making the claim, don't say, well, what would satisfy you? If you're making the claim, the burden is borne by you. Don't say, well, what evidence would you accept? Give me the evidence, and then we'll use the principles of logic and to determine whether that evidence actually proves the proposition. That's the way, rational people operate. Okay? But any evidence that would be presented, would have to negate the facts that that they're just men and women, and we can verify that independently, and that they force strangers to give them money. Those are the facts. Those facts show that they're a criminal organization. And forcing somebody to give you money does not create an obligation on you to pay and certainly follow them. It certainly doesn't make their rules magically apply to you and create obligations. So if you say, Mark, what evidence would you accept? Facts that would actually negate those facts that they're just men and women forcing everyone to pay them. And I gotta mention this too, because this has come out with this latest video, just like with a lot of them. It's the mere assertion, if you are physically in the United States, the laws apply, end of discussion. No. How does a written instrument from 1910, or let's say 1787, how does that apply to me, and why does it apply to me, and create obligations on me just because I'm physically in Arizona? To just assert it, look, if you're here, the laws apply, and that's, I've heard that before from actual prosecutors and bureaucrats, not just people trolling on YouTube and Facebook. That's called, just because you say it. What is the wind and nothing else? It's, vox Vox et praeter ex nihil. But it's just sound. Just because you say something doesn't make it true. They love to hit me with that. Well, Mark, it's not true just because you say so. But then they turn around and do the same thing. So if you're on YouTube and you have this inclination to say, look, if you're physically here, the laws apply, end of discussion. No. That's not how logic works. That's not how, just saying it doesn't make it true. Show me the evidence. So when I say that the governments, what we call governments, are just criminal organizations, well, show me the evidence. It's not true because I said so. Well, they're criminals because I said so. End of discussion. I said it on YouTube. Maybe I should just post that on YouTube. And then all of a sudden, no, I have the actual evidence. They're men and women. They're forcing us to pay them. Forcing someone to pay you is criminal. But they've got the law. Yeah, you gotta show where it applies. And to do that, they have to be more than just men and women forcing us to pay them. So, hopefully, that takes care of that. I've addressed the issue again. I'm not running away from it. It's not a matter of Mark doesn't say, I've said it, I don't know. This is, let's say this is the 5,000th time that I've said it. I've done this more than, this is not my first rodeo, so to speak. So I've been around the block a few times. As you can tell. And we got area code 281. You're live on the No State Project. What's your name? Where you calling from?
So my name is Anthony, and I'm calling from Texas.
Anthony from Texas. What do you have for us today?
Well, I've got quite a few things. A couple of things, just general discussion, general questions, and figured I might give you a little bit of background about where I'm at the moment. I've got the other day I got pulled over. Let's see. Apparently my license has been suspended. I was going 55 and a 35 allegedly. Didn't have any registration on the vehicle or anything, so I got a number of different tickets. Luckily, he didn't take me to jail, although he threatened to. He said, "Hey, I could tow your car and I could take you to jail." And I told him, "Well, I prefer that not to be the case, but obviously, it's totally your decision at this point." So he actually let me go. The reason my license is suspended is because for the past couple of years, you could say I've just been blowing off different tickets in different jurisdictions. So apparently they reported back to Texas, and apparently they've suspended my license now. So my intention is to go and start getting this taken care of, and I have my arraignment tomorrow.
Tomorrow.
So I intend to use pretty much all the strategies that you talk about.
Well, now I really feel bad I wasn't able to do the show Saturday, because I hate when people call for the first time the day before, well, at least it's just an arraignment. So, have you done any kind of role playing? Do you understand the basic principles of defending yourself against these people?
Yeah, I think I have a pretty good idea. I've been listening for the past year or so, and I haven't done any role playing exactly with anyone else. A little bit, sometimes with my friends. But I think I've got a pretty good handle on the strategy and how it's done.
Okay, so you know that the basic principles are that the burden of proof is on the accuser.
Yep.
So
we'll walk in tomorrow.
Does the judge have a burden of proof?
Absolutely not. He's supposed to be an impartial mediator and hold the prosecutor to their burden of proof.
Yeah, that's true. And a leading question as opposed to a non-leading question is?
A leading question is where the information that you're trying to elicit is contained within the question. They're typically yes/no questions.
Right. Now there are people that will go around.
I walk in.
Yeah, and there are some critics that will say that judges and prosecutors are not there to answer questions, and you're not supposed to be asking questions. But I've been to court many times, and it's been reported here on the show where people have gone through the script sometimes upwards of 10 minutes asking judges questions. So I don't fall for this nonsense that judges don't answer questions. They very well do. You can see on court TV and whatnot, you can see prosecutors asking and defense attorneys, you can see them asking judges questions. They ask questions all the time. So the thing is, the critics don't like the type of questions we're asking. So what they do is they lie saying, well, no, you can't ask questions. It's no kind of defense to ask questions. Really? I'm going to have to go ahead and disagree with you there. So, yeah, you should be asking questions. And so, have you filed a motion to dismiss and the discovery request at this point?
I have not. I got the citation about 10 days ago. The other thing is, and maybe you don't want to answer this over the air, but do you accept crypto? I tried to get onto the website, the sales page, and I didn't see an option there for paying in crypto.
I need to get that. I used to. I need to get that set back up again. So if for the time being, until I get that set up, maybe I can get that done this week. No, I don't, and I don't want to get into. I'll get that set up. So, but I would get that. I would get that filed because you would have been able to go in tomorrow and you'd be able to say, well, I have a motion. I'm going to take option number 3, which is, I'm going to basically motion to dismiss or demur to the complaint because the complaint is insufficient on its face. If there's no evidence of jurisdiction and go from there. Now, you still can do that, but he can give the prosecutor, he can get you off track there by talking about how the prosecutor hasn't had an opportunity to respond.
Yeah.
But bottom line here, which you say, well,
I guess go ahead and use my credit card and purchase all that maybe tonight, so I can have all those templates done, and I'll get those right away.
Yeah, I would email them to you today. I want to just cover a little bit more ground here regarding what's going to happen tomorrow. So you still could go in and you could say, well, I intend on pleading guilty, but I have a motion to dismiss pending. You know, and if he says, well, the prosecution doesn't have an opportunity to, hasn't had an opportunity to respond to this, what could you say to that?
Let me see. I guess maybe I could motion for a postponed arraignment.
To
give the prosecutor an opportunity to review my request, my Brady request.
No, because what happens is, it's more important that he's responding to the motion to dismiss, because that's an immediate thing. Because if the motion to dismiss is granted, there's no reason to respond to the Brady request and the discovery. What you don't want to do in most cases is give the prosecution more time to respond, because that waives your right to a speedy trial. So what I would suggest is, is say to the judge, and yes, you can ask a question. Well, excuse me, sir, not for nothing, but I'm only asking for evidence the prosecution's required to have. Aren't they required at this particular point to have evidence of jurisdiction to even have an arraignment?
I see.
Now, he could turn around and say,
they'll probably point towards the ticket and say that's the evidence.
That's great. Get some dialogue on it, and we'll address that in just a second. Now, the judge could say, excuse me, sir, I've been to Marc Stevens' YouTube. I've seen people, post there saying judges aren't supposed to answer questions. So I'm going to defer to the YouTube commenters, and I'm going to say to you, according to the YouTube commenters, I'm not here to answer questions. He will answer your question, because you can only, you can only defend against that which is disclosed. So if the judge is going to be insisting that there's jurisdiction to have an arraignment, then it has to be in the file. So that's why it opens the door to these questions. And if he says, well, I'm not here to answer your questions, well, how can I defend it? Is there anything in the file that would show that there's, well, you can ask, are you under the impression, sir, that you have jurisdiction to even force me into an arraignment? He's going to answer the question. Only when they run into trouble do they have the thing, I'm not here to answer your questions. Or they'll pull out the old excuse, well, I can't give legal advice, which is not asking if the prosecution if the file has evidence against you, is not asking for legal advice. What the implications of that evidence may or may not be, now you're getting into that area. What you should do based on that evidence, that's legal advice. So, if he does point to the ticket, how are you going to respond to that?
I'm going to ask him where on this ticket, what explicitly on this ticket proves that you have jurisdiction.
Yeah, but you can get a clarifying. Sorry?
I'm sorry, go ahead.
Well, you can ask a clarifying question first. You can say, sir, you're telling me that evidence proving the Constitution applies to me is on this ticket somewhere?
Okay.
Then you go for the throat. Now he's saying in front of all these people over here that evidence proving the Constitution applies to is on the ticket. Then you go for the throat. Exactly what on this ticket leads you to believe that?
So now, one thing you say is to try to not ask open-ended questions. And so I kind of wondered, isn't that an open-ended question saying what on this ticket proves that? Doesn't that give them an opportunity to equivocate?
Well, he's going to have to identify something, okay? And here, because you've got the ticket, and there's only one place he can go. There's only one thing he can say. And we know this from experience. He can turn around and say that you're physically here in Texas. Great. Exactly how does that prove your Constitution applies to me, sir? He opened the door.
Yep.
So at we're not always going to be able to avoid the open-ended questions, but as we're going from a vague claim to more specific, we're going to get to a point where we can say Just like when we have them on cross-examination, we have to ask an open-ended question, but we already know that they're not going to allow them to answer the question. What facts led you to believe that your Constitution and Code applied to me and gave you jurisdiction? They're not going to allow. So yes, that's an open-ended question, but we've got them in a corner. We know that they can't answer the question because there are no facts. So that's the thing with an open-ended question. You don't ask an open-ended question if you don't know the response that you're going to get. And here, we know the response we're going to get, so we can ask it confidently.
Okay. Now, before we actually go in front of the judge, my experience is you usually have a conversation with the prosecutor. And so I'm guessing this will be a good time to sort of practice what I'm going to say in front of the judge to the prosecutor, going through the whole logic. One thing that I always get from these guys, they say driving is a privilege, not a right. How do you respond to that when you're just sort of one-on-one with the prosecutor?
I don't even really get into that. I just want to know, look, sir, I'm happy to plead guilty today. Do you have any evidence to support your claim that just because I'm physically in Texas, your Constitution and laws apply? That's, okay. There's no reason to engage the merits. And if they say, well, sir, I think you're getting way ahead of yourself, isn't it? Until we establish that there's jurisdiction and that your codes apply, let's not go into what they actually say. Now, they may mention the driver's license as evidence of jurisdiction, and that's easy to deal with. Are you familiar with how at least I would deal with that?
Yeah, I believe so. They would say, the evidence proving our Constitution and laws apply is your driver's license. And I would respond with, so if I did not have this driver's license, your Constitution and laws would not apply to me?
There you go.
So I go with that. And then the other one, I believe there was another line of reasoning, and it will help me out here. It's, if I didn't have the driver's license, are you saying your laws wouldn't apply to me? And then the other one is to ask the cop, officer, if I did not have a driver's license, would you take me to jail? Could you take me to jail? Which they answer yes. And then they say, okay, so I'm forced to have this license.
It's better to say, so the license is not relevant to your determination of jurisdiction.
Okay.
Relevance is king, especially when you're in court. When you are in court, especially in cross-examination too, relevance determines what is and what is not admitted. The truth of what it is and what you think it can prove is not necessarily important if it's not relevant. Okay, so that's the big thing, relevance. So what you're doing there through that line of questioning is showing that the police officers saying that his determination of jurisdiction is based on the driver's license. You're showing that the driver's license is irrelevant to that decision because he would still have arrested you without it.
Okay, yeah. Okay, that's a good way to realign my thinking on that because, seeing it in terms of relevance now is going to definitely help me to have a better, more pointed response there.
Right, and I got to
I'm not sure if your listeners have ever heard this. So when I was on the side of the road, the cop had me pulled over. I gave him my license, and he asked me, he said, "Is this your current address?" And I said, "I'd prefer not to answer questions. My legal counsel advises me to remain silent." And then he kind of went on a spiel about the law and all this other stuff and how I have to tell him my address if it's current or not because of the law. So I said, "Well, does the law provide me the right to remain silent or not?" At that point, he said, "You know what? Forget it." And then he went and checked my stuff. But,
nice.
Is that, what do you think about doing that, about when you're with cops saying, "Hey, I'm going to exercise my right to remain silent"? Is that effective?
Yeah, and if he says you have to do this, I said, what are the consequences if I remain silent?
Okay.
I got to let you go, but I would say there was another point I was going to make, but let us know what happens. At least send a message or something that you're okay. And maybe get a report on Saturday. You can let us know what happened.
Okay. Hey, do you mind if I have one more question for you? And it's something I think you might get a kick out of. So the judge enjoys sovereign immunity. And then maybe, what do you think about this line of questioning? Judge, do you enjoy sovereign immunity? Of course, they'll say yes. And then saying, "Are you one of those sovereign citizens?"
Nah, I don't think I would do that.
Probably not the best idea.
And I don't know if it's necessarily accurate to say that judges enjoy sovereign immunity. They have absolute immunity. So, sovereign immunity can be certainly pierced because a police officer enjoys sovereign immunity while he's acting in the course of his job. But that, of course, police officers get stripped of that regularly. Not regular. No, let's just say they get stripped of it. So I may be splitting a hair, but I don't think sovereign immunity and absolute immunity are the same thing. Practically, it usually amounts to the same thing, because what it amounts to is you and I get screwed with no recourse against these people. So, hey, interesting question though. I appreciate that. But good luck and let us know what happens tomorrow, okay?
Yeah, thanks, Mark, for taking my call.
All right, we're going to go through. He's been on the big show before. We've got Kevin in Pittsburgh. Welcome back to the show.
Hey, Mark, how you doing?
I'm doing well. You have good news for us today?
No, my next trial is next week. The last time I was in front of the judge, he told the prosecutor that pretty much the only part of discovery he had to hand over to me was the camera footage. So he just sent me a letter. The prosecutor just sent me a letter from the chief of police, and it said that they taped over the camera footage. He contacted whatever Allied Solutions or whatever company runs the camera, and he said they taped over it. So, but
that's
the prosecutor.
So are they still, all right, a number of things. Are they still planning on prosecuting you despite the felony destruction of evidence?
Yeah, I called the prosecutor. I talked to him, and he said they only throw it out when they intentionally destroy the evidence, and I would have to prove that they intentionally did it and not just that it was part of their policy or accidentally or something.
And they're not going to give you nearly enough information to determine whether it was intentional or not.
Exactly.
Wow.
Well, I guess they said, the camera company said they taped over it, so I guess they're implying that's not intentional.
Well, you have to find out what the policy is for them and how often they do that. And this was something that was being used in a criminal prosecution. Why wasn't it in the possession of the police? And the prosecutor, rather. And we destroyed the tape. It was an accident, Your Honor. It was just, we didn't do it. That's what we do. We destroy evidence all the time. Why are you getting so bent out of shape, Mr. Defendant? It was not like it was going to show you were innocent. Because when they have the goods on you, on video, do me a favor, somebody. Try and find one example where the video supposedly exonerated the police, and it got destroyed. There was nothing we could do about it. So the videotape it contradicts the eyewitness accounts, and the video was in favor of the police. The eyewitness said the cops committed a crime. The cops say we didn't do anything wrong. The video vindicates us, and the video goes missing. Yeah. Yeah, I'll believe it. Yeah. Yeah. Well, the other thing, wow, that's bad. I would still make a case for that was the wanton and deliberate destruction of evidence that the prosecutor was not diligent in taking care of the evidence that he was required to provide you. The prosecutor should have made sure that was inside in the file so that he could provide you a copy with. The prosecutor was, still screwed up because he was responsible for that. So it shouldn't come down on you. It should be on the prosecutor for allowing something like that to happen. The other thing too is that, you want to bring up next week and say, well, I would file a motion to dismiss for prosecutorial misconduct, include the destruction of that, and also put in there that the prosecutor is being permitted to get away with a discovery violation. That is, Brady material is still something that they have to give you. To turn around and say that the only part of discovery they have to give you is the video and not Brady material, yeah, I call foul on that too.
Okay, so I mean, if I file the motion and then get in there and I'm in front of the judge, I mean, I guess I'll bring that up again, or we'll go over the motion.
Yeah.
And then, I mean, he's just going to take their side again, most likely.
Well, you have to make your objection. Objection, yes or no? Does the witness have personal first-hand knowledge of the matters they're testifying to, specifically that the laws apply to me and I violated them? Is there personal knowledge of that? And if so, what? Where's the proof that they have personal knowledge of that? Yes, they can run over you.
They just dance around that too.
They can, and you're going to have to bring this out. You're going to have to cross-examine them.
Okay.
So the police officer determined probable cause, right? It wasn't a lawyer that was running shotgun.
No, yeah, it was him.
Well, if he determined probable cause, what facts led him to believe that there was probable cause? And they'll jump up, and yes, this is a constant theme. And yeah, there's going to be someone saying that I still don't understand, or I'm too arrogant to admit that, when so you're going to ask for the facts that led him to believe, that there was jurisdiction and that there was probable cause, and the prosecutor will object. Objection calls for a legal conclusion. And I've known about Rule 701 for quite a long time. The thing is, when you go in and you ask that question, Kevin, you're not asking the cop to give you an opinion. You're asking for the facts his opinion was based on. Yeah. But they're not going to object if you ask him if he determined probable cause. In fact, you're not even asking him to form an opinion on the stand. You're only asking him to confirm that he did at the stop. Did you do this? You're not saying while you're on the stand, Mr. Police Officer, is it your opinion that there was probable cause? No, you're asking him just because then maybe 701 is actually applicable. But they're not going to object to that. No one thinks for a second if you ask a police officer, did you determine there was probable cause? Or is it your opinion that there was probable cause to stop me? Does anyone seriously think that they have to use 701 in that situation because a prosecutor is going to actually object to whether the cop determined probable cause or not? He's already determined that and mentioned that on direct examination, and it's probably in his police report and on the ticket. So if that happens, and this is probably what's going to happen, you have to then address the objection and say, look, no, I object that the prosecution should be subjected to sanctions for such an off-point objection. I did not ask for an opinion. I don't need Rule 701. I asked for the facts the opinion he made at the stop were based on. See, it's addressing the actual question you're asking and not getting into this, well, let's play, because, well, we're so stupid that we don't understand the legal, the fine legal details. No, you're asking a question, Kevin, for the facts that were within his knowledge to support the decision he made to stop you. I don't even, I mentioned if you want as an afterthought, say, well, and if necessary, if you are so corrupt and you're so dishonest as to still think that my question for the facts is asking him to give an opinion, then Rule 701 does allow him to do that. To me, it shouldn't be necessary. You've got to push them, Kevin, on the fact that you're asking for the facts his claim was based on. So the his objection has nothing to do with the question you're asking. And if you can't win there,
most of that stuff in
there. I'm sorry. If you can't get that, then yeah, at least you've preserved the denial of effective cross-examination for appeal. And that's really about the best that we're going to be able to do in a situation like that. Because obviously the deck is stacked against you. The judge is willing to accept the prosecution's off-point objection. And I've told everyone, I had the actual document on the website and in the video and in an article it was a year ago. It was Patricia Starr. Yeah, the Patrick Starr one. She repeated the same lie of the prosecutor, saying that the question called for legal conclusion, even though we were asking for the facts the opinion was based on. So, but that's really the best chance we have, I think.
Another thing I wanted, at the last hearing, the cop said there was no camera, and I had a picture of the camera, and then that's when the judge said they had to provide the evidence. So, I mean, as they fluff all of that, would that be good to bring up that he testified there was no camera, and now I have a letter from his police chief saying there is a camera? Ain't that like another blatant lie?
So they're saying that, so the police chief is saying there is video footage still, that it hasn't been erased?
Oh, no. He just sent me a letter and said that, there's a camera there and that they taped over the footage. The cop at the last hearing, he was telling the judge that there's actually no camera right there.
Oh.
And I said, that's not true. I have a picture of the camera.
If he does that if he's saying you can use that as impeachment, but something like that may not be considered enough to impeach him as a witness. I think when they turn around and don't let you question the witness on the facts that he relied on, that is either impeaching him or denying effective cross-examination. And either way, if you can't prevail at trial, you should be able to, there's any justice at all, any fairness, you should be able to prevail on the field. So, I appreciate the call, but I'm pretty lined up with calls now, and, but hey, good luck, and get in, do the role playing, Kevin. You've got to prep for this, so hopefully we're gonna, and I'll talk about more of this before the end of the show, is, we're gonna be doing regular role playing sessions, not necessarily here on YouTube, but we will be doing more regular, I will be participating in more role-playing sessions. So, we should be doing one right after the show today. I can't participate probably, but definitely tomorrow afternoon about this time, I will be on that one. So definitely check that out.
You do that on Skype or Facebook?
Well, we'll be doing it starting initially on Skype, and I may or may not broadcast it. I probably won't, but.
Okay.
But definitely after the show today.
All
so
right,
hopefully, you can get in. And I'm Frank Rizzo 3, and then that gets you started.
Okay, all right. Thanks a lot, Marc.
Appreciate the call. Kevin in Pittsburgh. We'll go to area code 219. You're live on the No State Project. What's your name? Where you calling from?
Is this Andrew?
This is Marc. Well, you're live on the No State Project. Is this Andrew? Your name is Andrew?
You're Marc Stevens, and this is Andrew. Yeah, it says Kevin from Pittsburgh, and that's not me.
No. Oh, well, I was saying that we had it. So, Andrew, where are you calling from?
Calling from Newberry, Florida, by Gainesville. I am the brother of Dale from Indiana.
Oh, that's right. He said that that you were calling. Okay, so what's going on?
Yeah, I got kind of a specific case. I have an Indiana driver's license. I just moved to Florida about a month ago. I just got my very first DUI in Florida in Newberry, and it's my first offense and everything is with my Indiana driver's license.
Andrew, how many DUIs does this make?
This is my very first.
Okay. The way you made it sound, I was a little concerned there.
Sorry, a little high-rated and high blood pressure and talking about. No, it was my first DUI, and it is out of state with my Indiana driver's license. I know my brother knows how to clarify things better, but can someone explain to you what happened? I got a DUI Saturday on my Indiana driver's license. They want me to either waive my right and transfer my Indiana ID to a Florida ID and then get my hardship license, or I can dispute my DUI.
Well, I tell you, the easiest way to avoid a DUI is not to drink, period. These are bad because you actually put people in danger, at least yourself, So these are really tough. And contrary to what some are going to say, Marc has never had any success in court. We did have last year a full jury acquittal on one of 2 DUI charges. So that's a full jury acquittal. So most of these don't happen that way. Most of the time we don't. When DUIs are resolved, they're usually with a pretty good deal that you can live with. So it's a matter of getting some leverage on the prosecution and hope, having them throw you a deal that's not going, something you can live with. This is not the same thing as no driver's license.
Right.
So
let me put it this way. Okay. Got arrested Saturday night at like 1 in the morning. I went to court at 9 a.m. It was my first appearance, and I ended up getting a ticket for the DUI, which I have a court appearance now on the 20th, which I didn't even get any of the information while I was in jail, so I bonded out. And I also have a ticket on the side for crossing into a bicycle lane. When I talked to the clerk's office, they have 10 days from when I got my license suspended, which is time of arrest, either file for a hardship license or dispute it. Now, I'm not 100% sure if when I go to dispute it, if it's to the clerk's office at set time 5 days from now, or if it's when I have my court date on the 20th for the whole DUI case.
I would file, if you're going to go that route, what I would do in that situation, I would file a motion to dismiss and the discovery request. And like any other document, you get that filed with the clerk of the court. The complaint is in, and you have to, and there'll be a certificate of service on there. You have to put the prosecution's address in there also, and make sure that you send a copy to them of every single thing you file.
Okay, so also, my brother today, the one you know, and he told me that what I need to do is call back the clerk's office, or one I gotta ask what charges are going to be filed against me. Say great, and then ask what facts of evidence are shown that prove that, and how they apply to me.
Well, you're not doing that with the clerk unless the clerk is making an assertion of jurisdiction over you. Sort of like when clerks say you have to pay $50 or pay a bond or bail in order to file any paperwork or see the judge. So I would ask them in that case, so you have evidence of jurisdiction to even require me to do that, right? You have such evidence, or you just, making it up as you go?
I do not have evidence. I got released yesterday. I didn't get any information until I was released about any of my tickets. I did see a judge for my first appearance on Sunday, and that's what gave me a DUI, and I apparently have to go back on the 20th, which I wasn't given that information until I was released after I was released. Sorry, there's a lot of this. I'm not trying to eat up too much of your time either.
Yeah, I do have a lot of other calls, but what I would say here is one, do us all a favor, stop drinking. You're not, I don't, some people, they don't want to hear that, or they whine and go, oh my gosh, now he's talking about, not hurting animals. But this is a matter of principle, and what we do on the show is a matter of principle, contrary to what, a handful of critics think. And it's just wrong. So don't do that. I've seen cars I've lost friends to DUI. Not that they were driving drunk, but because somebody else was. So that's it. I would file the motion to dismiss and the Brady request and discovery, and use that as some kind of leverage to get a really good deal. Because chances are you're not going to do well if you take it to trial. So.
Okay. Well, I won't eat up any more of your airtime, and I'll contact my brother or whatever it takes, and hopefully hear more from you and possibly your intake from it. Okay,
sounds good. Appreciate the call. Andrew in Florida. And that's the thing, DUI is not, we talk about do no harm. That what underlies the underlying principle of this, do no harm. And when you drink, aside from the fact that it's really, damaging to your own body. I mean, finally, I think there was something released last week that said scientists now say that no amount of alcohol is healthy. Of course not. Ask your pancreas that. No, it's not. So, yeah, that's something that we want to, keep in mind. But then to drink or to get stoned and get behind the wheel of a car, I can't defend that any time. So, DUIs are tough because you're violating a core principle. Let's not do that anymore. So if you don't give a damn about your own body, at least stick to the principle, do no harm. Don't get behind the wheel of a car or a motorcycle. Just stay off the road if you've had some. Again, do no harm. Not that difficult. Not that difficult. We got a new caller, area code 720. What's your name? Where you calling from?
James calling from Colorado. I mean, not Colorado, South Carolina.
Wow, you're really off there, South Carolina. You don't have to give a last name, James, but I lived in South Carolina for a little bit. Are you near Augusta?
I'm in Charleston, so whoever that is.
Oh wait, Augusta, Georgia. I was at Fort Jackson. I can't remember where Fort Jackson is in South Carolina. Is Fort Jackson Charleston?
I think so.
Okay, I did live in Charleston for a little bit.
All right, Mark.
What do you got?
Okay, so I'm impressed that I'm actually talking to you. All right, so I've been following you for a while, and I've been following a lot of other people and buying books and everything, just trying to learn this law stuff and everything. So I found that, so I want you to know, I want to see what you would say about this. This is amazing. So I've been studying about law and everything. I found out there's so immigration law. I looked into the immigration law and everything. You can literally look it up and everything. So what I found out, there were two forms of government in North America. Actually three, the Indians or whatever, Native Americans or whatever you want to say. But actually, for us, there is two forms of government and two forms of citizens. This is what I learned. I don't know, I will see what's your opinion. So I learned, and I have pieces if you want to look it up. So the first one, the people of the United States resident within any state or subject to two governments. One, the state, and the other, the national. And the state is actually a capital letter. If you look up in law, it's part of the United States Federal Corporation. So there's the de facto government of the United States Federal Corporation. And if you want me to give you the code for this,
it's probably going to be Title 28, where the federal government is defined as a corporation. That's because yeah. Okay, well, they ruled back in the 1790s, the United States Supreme Court, that all governments or states are allegedly body politic and corporate, and that's just the way they operate. There's no mystery to that. It's okay. But I thought you were going to say that, well, in 1971, the federal government was incorporated and then tricked everybody by using their name in all capital letters, and none of that has any merit. So I'm hoping you're not going there.
So this is just the cases so far I'm learning this. So there's two forms of government. This is what I learned so far. And there's a capital S as part of that's what it says, part of the federal corporation. And that's capital S. You search up the capital S and you'll learn it in the Cardinal's Law Dictionary. Search up the capital S and it will tell you at the Samoan Islands, District of Columbia, et cetera.
No, so you wait. I don't want to spend too much time on this because we've covered this kind of stuff before.
Okay.
Part of this comes from the fact that some people don't get statutory construction. I know that words in law and in statutes or whatnot, a person can mean a human being. It can mean a corporation and a sole proprietor. It can mean a city. Correct. And it can mean a state. So it could be in I get it. I understand that. But this thing about the states only being corporate entities of the feds, well, even if that's true, is there still any evidence that their rules apply to us? Is there any evidence that would suggest that they're a legitimate organization?
Yes, I see your argument there, but the judges are gonna just ignore you. They're gonna just keep on going. They keep going without knowing the law.
But no, they know their laws and they have their interpretation of them. And the road you're going down, if you're intending to do it in court, is a bad one because legal interpretation and bringing pure issues of law, where you're only discussing what the law says and what it's supposed to mean. When they have conflicting decisions, that's really bad. You're going to lose every single time. Every freaking time. You simply will not win, especially with these kind of issues you're raising. I would prefer, and it's a much easier way to make your case, by showing that they don't have any actual evidence. Because they can't lie about the facts. All they can do is lie and say that they don't have to prove that. Well, the prosecution, they can lie saying, get ready for it. I'm going to do it again, everybody. Jurisdiction's a pure issue of law. It requires no evidence to prove it's true. All the prosecution has to do is prove you're physically here in South Carolina. They have to lie if they make stuff up like that. They have to lie saying
they're liars.
Yeah, exactly. And the easiest way.
They're magistrates.
Yeah, but the more effective way, though, James, to show how unfair it is to get them on the facts, not legal interpretation. They don't give it, you can still do it. Bring a pure issue of law. Doesn't even require a trial.
What happened?
There has to be proof, though, something in the record that's how they're charging you. And there isn't that. It's just like the name in all caps. There's absolutely no evidence whatsoever to show that they're charging you that way.
All right, so Mark, so I know you're busy. You're a very busy man. If you can just write up this YouTuber and look into it, and that's where I'm getting most of my information. It's your choice now. The YouTube name is called Sovereign Living. And that's all I'm going to say. Sovereign Living. And then if you look it up, that'll be great. And maybe have a topic about, hey, this YouTuber, et cetera, where he's making mistakes on or whatever. It'd be great. But if you just look up 5 minutes, just for 5 minutes, I would donate money if I could. If you bring that up, I would donate $100 to your chat thing. If you bring up Sovereign Living and tell him if he's making mistakes or not, please, it would be the greatest thing in the world. Or maybe I'll put $100, $200 if you ever do a topic about it. I've been following you all my life.
I'm more inclined to do that and debunk something like that than a mate down under. Okay. He actually paid me to watch a flat Earth video, and I just couldn't get through the whole thing. It was just.
No, don't do that. Don't do that. That does not help anybody.
No, that's all right. Well, if you want, you can contact me off air, or we can do that. And maybe if I have the time, depending how long it is, and if I feel it's necessary to do a video debunking that, then I can go through that. Sure.
Okay, great. Thank you.
You're welcome. I appreciate the call. What James is bringing up is something it's unfortunately still fairly common, and we're always going to see this. One of the things we have to look at, and whatever claim is being made, why do they think that's true? What other sources? And they have to be credible sources. It's just like people thinking that the G behind me, is from masonry. No critical thought whatsoever. Well, it's not between a compass and square. It's got flowers on it. I'm not saying it. So it's the same. It's the same here, where someone's making these claims that all the state governments are just sub-corporations of the federal. No, they act in concert together. So what I look at it that like with other criminal, like for example, the way organized crime is set up. You have the gang, which we call cities. And then you have the syndicate, which we call states, because the cities, and counties, they work for the larger entity. And then you have a cartel called the United States, and you've got 50 or more because you include Puerto Rico and the territory. But if you're going to court, which is what most people are tuning in for, you got to look at what they're actually claiming. So they're claiming that their laws apply because you're physically in, South Carolina or wherever it happens to be. And the only thing they can do is just keep repeating it. Dude, you're here. If you're here, the laws apply. Why is that true? What is the source of that? Well, because somebody else said so. It's turtles all the way down. There's no actual evidence to support it. But here, they may be sources that, somebody had said, somebody was putting in here Twining. It's actually Twining versus New Jersey, trying to say something about the Constitution not, under the government, it's a statist view that, the statutes and laws don't apply to actual citizens. And they think that Twining versus New Jersey, says that. And, I've done this on live broadcast before. I'm not going to do it now because I don't have enough time, where I've actually looked up the cases that they were talking about and plugged in the citation, the quote that they said was in the case. It wasn't there. Wasn't there. It's just like the one, oh my gosh. So I don't even have the time to get into that. But look at the sources. So, and then there may be things that are actually true that, there are, the law is vague and there are plausible interpretations that are different than what the IRS has, for example. But that doesn't do you and I any good because they don't give a damn. They have conflicting decisions to yours. In fact, okay, and they are always going to win. And anything that goes along the lines of, well, they just tricked everybody. And what they've done is if there is a trick that was pulled on people, it's that government is a legitimate organization. That they've tricked everybody. Because people don't want to look at the evidence. So when confronted with the evidence, they want to just dig their heels in. No, the laws apply because you're here. Really? Really? And that's true. Why? And in fact, look, you're using California as an example. If you just have money from somebody in California and they send you $1,000 in Arizona, they believe their constitutional laws apply. You never set foot in California. How would a written instrument from 1879 apply to me in Arizona because someone in Fresno sent me $1,000? What are you going to say then? But you're in Arizona. Comedy. There's an agreement. Critical analysis, critical thought, logic, reason. Things are not true just because you want them to be true. And things are not true just because people you look up to, people you call honorable, say so. Just because a lawyer said it, just because a judge, a lawyer with a black robe, just because they said it, doesn't make it true. Well, it makes it the law. So what? Where is the evidence that it applies in the first place? Evidence. Evidence. Let the data speak no matter what the data say. And so the evidence says that they're just men and women forcing us to pay them. That's what the evidence, that's the evidence. All that other stuff is coffee house BS, to borrow a phrase. The evidence is what is important, and there is no evidence. We're going to be doing more role-playing because we have a solid foundation of proof that people doing the role-playing and doing the role-playing makes you more effective in court. But I want to, there's going to be role-playing after the show. If you are interested in that, I can help you get into the chat room. It's Marc, it's Frank Rizzo 3 on Skype. And then look tomorrow. You can contact me at Frank Rizzo 3. I may make the first one tomorrow. I may broadcast that on YouTube, just so people know about it. But the role playing, so we can go through the basics. We can go through the basics and better prep for court and be more effective in court. This has been live, commercial-free episode of the No State Project, episode 78 from the Fortified Compound in Mesa, Arizona. Big thanks to Jan, the dude, and also Don for support of the show. The show and the next show on Saturday will be brought to you by them. I do appreciate everyone tuning in. And we will be live Saturday. Shouldn't be any kind of problems. And so, as always, till then, salud.